conviction at a trial would, and that this is true regardless of any advice or anyone else.
You can get deported.
Are you a U.S. citizen?
Oh, yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction?
Yes.
Just as there would be from a conviction following a trial.
Yes, ma'am.
For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury because you're in fact guilty.
Yes, ma'am.
With respect to indictment 22 FC 183-572, where you're charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, count 47, conspiracy to commit a crime, count 48, participation in criminal street gang activity, and count 55, conspiracy to commit a crime. How do you plead, guilty or not guilty?
Guilty.
Is this involuntarily given with a full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today's date for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
And Your Honor, if this case were to go to trial, the state would expect to show and prove that between January 24th of 2013 and May 8th of 2022, that the enterprise known did unlawfully conspire to acquire and maintain and control of the United States currency and other personal property through a pattern of racketeering activity, and also, while members were associated with that enterprise, did unlawfully conspire to conduct and participate in directly in racketeering activity as described in our indictment, Your Honor. Associates of the enterprise, YSL or Young Sumlin, they did conspire to associate together with others for the common purposes of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. And in furtherance of that conspiracy, the defendants engaged in the activities enumerated within our indictment. Some of the objectives, Your Honor, include but not limited to preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence. Also preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating an allegiance to the enterprise and a willingness to engage in violence on its behalf. And those are just some of the ways in which they try to further the enterprise. Your Honor, the state would expect to show that this YSL started in the late 2012 in the Cleveland Avenue area of Atlanta, Georgia, and that some of the founders of this enterprise was Jeffrey Williams, also known as Young Thug, also known as Slime, Walter Murphy, also known as DK, and Trotavia Stevens, also known as Tick, and also known as Slug. That this group uses a variety of identifiers, including colors, clothing, tattoos, and hand signs, as well as verbal and written identifiers. And Your Honor, specifically, how Mr. Sumlin will contribute to this enterprise is that we have a number of Instagram postings of Mr. Sumlin. The first being, Your Honor, Mr. Sumlin was incarcerated, I believe, between 2014 and 2017. Upon his coming home from prison, we have a picture of him in that video. It was a video. In that video is one of the co-defendants, Jeffrey Williams, and they posted this on social media, and the tag of that was original slime shit, and that was posted and tagged by this defendant, who's also known as Obama. We also have some imagery, Your Honor, also posted on social media with this defendant wearing red clothing with, on that clothing, it has MAXA, which is a play on MAGA, which is Make America Slime Again. And then he also has several tattoos identifying this on his body, Your Honor. We also have a couple other postings of this defendant with other members of YSL posted on the internet. Specifically, two of the crimes that he was charged with, Your Honor, in this indictment are actually two telephone calls of individuals who were both housed at the Fulton County Jail. The first phone call was on February 22nd, 2022, Your Honor. And this is a phone call by one of the co-defendants, Christian Eppinger. That individual called this defendant asking permission from a person known as Slime, whether or not he would have permission to harm Wyatt Benalucci, also known as Mr.Shardt. Your Honor, that phone call came after Mr. Bennett had already been attacked by other members of the YSL gang in the jail. Your Honor, although Mr. Sumlin did take the phone call and agreed on the phone line, it does not appear that that ever took place. Nothing happened to Mr. Bennett subsequent to that phone call. Second, Your Honor, we have a phone call on April 7, 2022, where another co-defendant by the name of Cordarius Dorsey also called Mr. Sumlin on a jail call and asked Mr. Sumlin to either rob or kill an individual known as Head. Mr. Dorsey provided Mr. Sumlin with a phone number to kind of set up an armed robbery and whatever would happen after that armed robbery. We later found through investigation that Head was an individual by the name of Harold Bennett. What we learned is there was nothing that happened to Mr. Bennett afterwards. So there was this agreement on the telephone. However, it does not appear that anything happened subsequent to those two telephone calls. Your Honor, those things, the social media posts, in addition to the those two phone calls, is how Mr. Sumlin has furthered the enterprise in this case, and that's what the state would have expected to prove in this case where they're on the trial.
All right, thank you, Ms. Hilton. Mr. Hoover, anything on behalf of your client?
No, Your Honor. We just.
Okay. Reserve your right to assert your Fifth Amendment privilege against self-incrimination. Is that correct?
Yes, sir.
All right. You also agree to testify as to the acknowledgments that you have made within the terms of the plea agreement. Is that correct?
Yes,
the factual acknowledgments.
Yes,
right?
sir.
Okay, all right.
Next week.
Yeah.
So, in preparation of him coming today, I reviewed his statement that he gave to Investigator Viverito and other law enforcement investigator J.P. Miller. And my understanding is the state is going to ask him questions based on things that he has personal knowledge of, and I understand that that's out there for potential impeachment. I'm just making sure we're on the same page. Investigator Viverito asked him to speculate about a lot of things, why certain things would have happened. He makes it clear that he was locked up during the Donovan Thomas murder. He knows nothing about it. He also makes it clear that he does not know about Drink's murder, and he's just, kind of speculating about why this would happen. There's a lot of talk. How much would Jeffrey have paid them? Why, the hypotheticals. Why would Shannon have done this? And the reality is, Mr. Sumlin has no firsthand knowledge of who did what. He's just kind of going off the cuff in this interview. I just want to make sure that we're all on the same page, that none of that is, nothing that he is speculating or just kind of hypothesizing about that he does not have firsthand knowledge of will be inquired about.
Good morning, Your Honor.
Good morning.
We will be making inquiries into, we will be laying proper foundations, and we will be making inquiries into areas that we believe he has knowledge of. If we will not improperly ask a question that we've not laid a foundation for him having knowledge of. That's what we can say. I don't think it's proper for counsel for the defense to attempt to curtail our direct examination based on what he believes a witness has knowledge of.
Okay, well, I don't mean to curtail anything, but if the state brings out things that he does not have firsthand he had knowledge of, and it's improper, I'm going to be moving for a mistrial with prejudice, and we all know that now.
Yeah, okay. So I would think that, y'all, do I have I don't know if I've got a copy of the interview or not, but y'all could get together and see if you all can agree on what's clearly not within his knowledge and what might be, and then we could potentially litigate that beforehand on Friday.
We could do that. We could,
You do have a copy of it, Your Honor. It's in that 30 witness.
Okay.
In his folder.
and Your Honor, we could definitely get together and talk about things that we believe, or one party believes he does or does not have direct knowledge of. But again, given the way that the interviews have gone and the examinations have gone, I don't, again, think it's proper to prematurely try and curtail certain things. I believe that
It is absolutely proper to try to make an evidentiary determination beforehand on things that would be objectionable.
I don't disagree with what the court is saying. We seek to, or we establish a foundation for his knowledge of certain things that the defense does not believe he has knowledge of. I believe that curtailing our ability to make that foundation would not.
I don't think that's what he's asking.
Well, if that's not what he's asking. Okay.
So
It's caught in the crossfire.